Hello, everybody, and welcome to the webinar on self-help conservatorship. We are so delighted to have Neil Libbe joining us from the self-help court. He is one of the attorneys there, and he's going to help explain what this process is all about and how you can do how you can do a conservatorship without an attorney and paying those $3,000 to $4,000 for that process. I am going to quickly show you how to find out where you can get this information later in case you want to show it to your spouse or an adult sibling so that they too understand. You should be able to see my website. I'm going to go to e-learning. This is on PHP's website. And we don't really have a category for this one yet specifically, but I think you'll go to general topic views. For those of you who are considering conservatorship and haven't yet applied for SSI, we also have the public benefits. And on there you will find videos on how to apply for SSI and how to apply for in-home support services, as well as other videos from other sources. But the first two are done by our staff. Actually, they're done by me. And you can quickly learn about how to get ready for that process. If you want to know about other things that are happening at PHP, because we have so many things coming up, you can click on the calendar, which is over here on the right. Everything that's happening that has been submitted either on our website or we've submitted ourselves, it's all coming up here. And you can see there's 15 pages of good stuff coming to you. You would just click on one of these and then you'll get the details, and you'll also be able to save a space if it's a PHP event. If you only want PHP events, hover on calendar and click on PHP events. If you know about an event, please feel free to submit it, and it will be approved usually within 24 hours, Monday through Friday. So let's get to the webinar. There's so much more on the website. We could spend the whole hour and 15 minutes on the website, but you came here to hear from Neil. So I'm going to change presenters and give him control of the screen now, and you'll be seeing his presentation. If you are seeing your panel for GoToWebinar, there are two handouts. There is Neil's presentation, and there's also the Limited Conservatorship Handbook that you must read and say that you read, that you're going to need, and you can download them both from here. So without further ado, I'm going to hand this over to Neil. We're so grateful for you being here today with us and helping to just make this not so complicated for families. If you have questions during the session, go ahead and enter them, and I will be tracking those, grouping them, and then asking at the end of the presentation. All right, here we go. I'll see you guys later.
All right, thank you so much, Trudy. I want to thank Trudy and everyone over at Parents Helping Parents for asking me to present during this webinar. And also, they've been a great partner as helping us to deliver services to people that really need it. Everyone here at the Self-Help Center and the Facilitator's office are really dedicated and passionate about helping to deliver justice to people, and that's giving people access to the courthouse who wouldn't normally have it, helping people that either can't or aren't able to afford to hire an attorney, and so we love helping people. And so it's really my pleasure to present this information about limited conservatorships. So as an outline of what we're going to be talking about, first I'm going to talk about generally, what is a conservatorship. We'll talk about some common legal terms. I'll describe the different types of conservatorships and some of the factors that you should be considering when choosing what type of conservatorship is the right one for you and your family. We'll go over an overview of the process for starting a limited conservatorship, including what are the service requirements, what family members are entitled to notice. And then we'll talk about what to expect at the court hearing, and then what are the sort of few procedures to do after the court hearing after you're appointed as the conservator. So this is all designed hopefully to give you information so that you're equipped to kind of make decisions on what path and what route to take, how to strategize, so that you can represent yourself without the assistance of an attorney. At the Self-Help Center in the Facilitator's office, we don't give out legal advice. We just give out information. We help with forms. So if you have a strategy question, if your question is, what should I do in my specific case? Those are questions that we can't answer, but there are a lot of resources out there, not just through our office, but through the Judicial Council's website. Parents Helping Parents have a great website, and our Santa Clara County Superior Court website has a lot of great information on there as well. And we'll have links to each of those websites at the end of on one of the last slides. So to start, some of the common terms that you're going to run into over and over and over again as you're dealing with conservatorship type issues is petitioner, conservator, and conservatee. So the petitioner is the person that's opening the conservatorship case. And they can wear multiple hats. They can not only be the petitioner, but they're also going to be one of the conservators. The conservator is the person who's going to help the conservatee retain their maximum independence, and they're going to have certain limitations and responsibilities as it relates to the conservatee. In the probate code, it lists who is the person that can be a conservator. And they have an order of preference there written into the code, either a spouse or a domestic partner first, then an adult child, then a parent of the proposed conservatee, which it may be the case for most of you, then a sibling, any other person elsewhere authorized under the law, and then finally a public guardian. The conservatee is the person who needs your help with medical, legal, or educational decisions, and it's usually, in most cases, it's going to be your child. So you'll see over and over that we're going to refer to, when we say conservatee, that's what we're referring to. It's likely your child or whoever it is that needs help in managing both their personal and potentially their financial affairs. Conservator is the person who's going to be helping them out, and the petitioner is the person that's actually starting the case. So there's different types of conservatorships. There's a general conservatorship, limited conservatorship, and the Lanterman Petra Short conservatorships, or LPS is what we call them, conservatorships. The LPS conservatorships are generally started by the county. It's for people that have some serious mental health problems or are requiring treatment, or in a facility. There are people that would not, the conservatees in those cases would not agree to special arrangements or treatment on their own. And so we won't be talking about those specifically, but I just wanted to raise your awareness about some of these other types of conservatorships. General conservatorships are usually for adults who aren't able to make decisions for themselves. Generally, it's for elderly persons, but younger persons can also have a general conservatorship as well. Usually it's in cases where there is a really bad accident. What we'll be focusing on today is limited conservatorship. In those cases, those are for adults who were born with or had a developmental disability that started when they were a minor child, and that developmental disability is going to continue into their adulthood, and it's reasonably likely that it will continue for the foreseeable future. And so as we get into our next slides, the general conservatorship and the limited conservatorship are broken down further into two different types of conservatorships. So under the umbrella of a limited conservatorship, you can ask for a conservatorship of the person, and that's where you're going to help the conservator helps the conservatee make decisions dealing with their daily life and personal issues, medical decisions, education, securing housing, those types of things. Whereas the conservatorship of the estate is handling their financial matters. Generally, you won't need a conservatorship of the estate if the developmentally disabled adult receives public assistance like SSI and has no other assets. Because if they were to receive if they had any sort of financial assets or receiving income, then they would be disqualified from receiving any of those public benefits. And also, if a developmentally disabled adult's earning a wage, then it's unlikely that they would need someone to manage their financial affairs because they may be capable or have the capacity to manage those things if they're also able to work and earn a wage. But these are all, and we raise these just so that you can just be aware of these different types of conservatorships, and so you can tailor based on the needs of your family what your conservatee needs assistance with. In the cases that we help with through the Self-Help Center, we only help with limited conservatorships of the person, not of the estate. And in some cases, if you're not able to make a decision on what sort of conservatorship you need, you may need to consult with a private attorney so you can get some legal advice. And I know that there's, estate planning can be an important component for making sure that your child's taken care of. And if they are receiving public benefits, then you might want to bring up with an estate planning attorney whether they can prepare a special needs trust so that funds are set aside to take care of the conservatee without them actually being owner of them, to make sure they're not disqualified from public benefits. There's not too much more I can tell you about the estate planning side or conservatorships of the estate, just because that's not something that we help with through the Self-Help Center. But I just wanted to give you that information so that you had it in case you're interested in getting legal advice on those topics. Some people frequently ask, how many conservators should they propose in their paperwork when they're opening a case? And it just depends on the family. You want to make sure that the people that you're proposing as proposed conservators get along, because the way that we set up the paperwork is that each of the proposed conservators have equal powers to act. It's not a situation where you have one primary and then if they choose to not be the conservator anymore, that somebody steps in their shoes and then they take over. Everyone that is appointed as a conservator all have equal powers. One signature will bind all the other conservators. So you want to make sure it's people that you get along with, and if it's someone that you end up having a disagreement with, you'll have to come back to court to have the court be a tiebreaker. And sometimes people ask, why is there only one petitioner, but maybe there's 2 or 3 or more proposed conservators? It's just simply because only one person is the petitioner, only one person is actually opening the case. But on all the forms, there'll be places where you list all your proposed conservators. We talked briefly earlier about, what is the requirement in order to open up a limited conservatorship, and that requires that the proposed conservatee have a developmental disability. So here I'm just putting up for your information, and it's in the handout that you can download, what the probate code defines a developmental disability as. And you can read through that if you'd like. In a limited conservatorship, the court is giving the proposed conservators limited powers, limited authority over some of the decisions for the conservatee. And so these are some of the powers that can be granted as part of a limited conservatorship. 1, to fix the residence or specific dwelling of the limited conservatee. 2, to have access to the confidential records and papers of the limited conservatee, including but not limited to regional center documents and school records. 3, to control the right of the limited conservatee to contract. 4, to give or withhold consent to medical treatment for the limited conservatee. 5, to make decisions concerning the limited conservatee's education. So you can see these are just specific things that you're empowered to do. It's part of a limited conservatorship. And that's contrasted with the general conservatorship that we talked about earlier, where the conservator is granted all powers and only exceptions are made as to things that they're not authorized to make decisions about. So you can see that in limited conservatorships, very specific powers and only those. And you can think about the great responsibility that comes with being a conservator. you're responsible for these medical decisions, where the conservatee resides. And so when you're petitioning the court, we'll talk about this in a little bit more detail later, they're going to do a background check to make sure you're the right person for the job. And there's the the Conservator's Handbook that you have to read, and that can answer a lot of common questions, but it's also going to detail, what your powers are, what your responsibilities and duties are. One of the things that you have to put in your petition is to make sure that you don't have conflicts of interest. And so, and all of these are sort of checks and balances to make sure that there isn't fraud happening, that the person asking to have someone conserved is not somebody that's looking to take advantage of them. Generally, everyone that we help are parents, and it's never really a problem. But overall, a limited conservator's responsibility is to help the limited conservatee develop maximum self-reliance and independence. So this can be training or education, medical and psychological services, social opportunities, vocational opportunities, and other appropriate help. Here's a link to the handbook, but I think Trudy's made that available for you to download as part of the materials, the handouts, as part of this webinar. And this is going to be required as we go over some of the more step-by-step instructions when you prepare for the hearing. It's something that there's going to be a form that you sign saying that you downloaded it and that you've read it. And so that'll be required at the actual hearing when you're appointed. After the court makes an order saying, okay, you've been appointed as conservator, go downstairs to file this order. When you get down there to the clerk's office, that's when you're going to file the paperwork saying that you have read and have the handbook. It used to be in the past that you had to, pay. I can't remember how much it was, but you had to pay for this book. It's a pretty thick book. But now it's available just to download for free. You can just have it downloaded on your tablet or on your phone, and you can just show the clerks that you have it on that device, and they won't make you present an actual hard copy. They used to have these books printed out and really nice and bound and everything, but now I understand that they're just printing out Xerox copies, and they're not very nice. So just if you want to print it out, you can have a hard copy, or you can just show the clerk's office when you file your orders that you have it downloaded on your phone. So it's nice to get into the digital age a little bit there. There's two powers that if you do look at, you may have heard that in other counties, or maybe if you've looked at some of the forms for requesting a conservatorship, that there's one of the powers that you can ask to have over the conservatee is to consent or withhold consent for them getting married, and also the power to control the limited conservatee's social or sexual contacts. And neither of those are granted in Santa Clara County. I think that's the same in San Diego, but I think some other counties will consider granting those powers, but those are not granted here in this county. The timing for when to ask for a limited conservatorship, it takes 2 to 3 months to get a court hearing date, and the conservatorship is only for someone who is an adult. So it doesn't make sense to file prior to the child being 17 years and 9 months. So if they're an adult, or if they're about to turn 18, then that's a good time to actually file the paperwork to ask for a court hearing, because your hearing will be in 2 to 3 months. So the hearing will end up being right around the time the child's about to turn 18, and the orders would take effect once they turned 18. Sometimes we get requests from people when their child's still only 16 years old, and we'll tell them that due just to the high volume of requests for help with this paperwork, we ask them to resubmit their request to register for one of our workshops when the child's at least 17 and a half, 17 and 9 months, so that it's closer to the time that they're turning 18. So for starting the process to ask for a limited conservatorship, when you fill out all your forms, which we can help you with in the Self-Help Center, and and I'll show you, there's a link later on that'll show you how you request our office to help you. But just to give you sort of a broad strokes overview of the process, when you start the process, you'll be filing all the necessary paperwork at the probate clerk's office. It's located at 191 North First Street. And there's a filing fee of $435 plus a $900 probate investigator fee. But these fees are in every case that I've helped with, every single time the fees are waived because it's based on the circumstances of the conservatee who's usually receiving public assistance, isn't working, and so the fee waiver is granted in almost every case. And you're going to file, so you're filing in our county only if the conservatee lives here. Sometimes we get requests from families where maybe the parents work down here and they know that our self-help center offers this service, so they want our office to prepare the forms for them. But if their actual residence where the conservatee lives is in Alameda County or San Mateo County or one of these other counties, they'll have to file all of their paperwork and their petition in the county where the conservatee resides. And so, and we won't be able to help people with their paperwork if their conservatee lives in another county. The reason for that is that each county has their own set of local rules. We have tons of our own local rules and local forms that other counties would not necessarily know how to fill out. Like we have our own court investigator, and there's special forms that go to our court investigator. And without filing those forms, it could delay or end up having your request denied in our county if the paperwork's not filled out right. And so we don't want to set up paperwork for another county because we're not familiar with the other counties' local rules and local forms. We are starting a project to try to team up with other counties like Alameda County, Contra Costa County, San Mateo County, for those people who, for whatever reason, find it more convenient to attend a workshop and have our office help them fill out the forms, while at the same time being knowledgeable enough about their local court procedures and local court forms so that all the forms are properly filled out for that other county. But we're just in the starting phases of that program. And so that's going to be potentially something we can offer in the future. But for now, the only people that we can assist with their paperwork is if the conservatee lives in Santa Clara County and the case is going to be opened here. So after the paperwork's filed, again, this is just an overview. After the paperwork's filed, then certain people are entitled to notice of the court proceedings. One of those people is your proposed conservatee. And so they will have to be served with a copy of the petition that opens the case, a copy of the notice of hearing for when the court hearing is, and a copy of what's called a citation. It's like a summons in other types of cases. And a lot of people commonly ask, well, wait a minute, my child who is autistic or has some other developmental disability, they're not going to understand what I'm handing them. And that's okay. It's still required by law that they receive a copy. What happens with a copy after it's handed to them doesn't matter. It just matters that all the legal requirements are met. But it's a very common question. Other people that are entitled to notice of the proceedings, other people that have to receive a copy of the petition and notice of hearing, are any spouse of the proposed conservatee, the parents of the proposed conservatee, any brothers or sisters who are at least 12 years old, all grandparents, that's maternal and paternal, that's the parents on both sides, the San Andreas Regional Center, if the conservatee is a client there, and the public defender. And so in these cases, we were talking about how as a part of a limited conservatorship case, the conservators are gaining these powers over the conservatee to make certain decisions for them. So in a way, you're limiting their rights, even though the goal is to help them maintain their own self-reliance and independence. Because you're, in theory, taking away some of their rights, they're appointed a public defender in this county. The public defender will meet with them the day of the court hearing and the public defender will actually do a bit of the talking at the hearing itself. And so that's why the public defender is entitled to notice, so they know where and when to show up. And the San Andreas Regional Center is noticed so that they can prepare a report about the proposed conservatee. That can take a little bit of time, so it's important that they are served right away with a copy of the petition and notice of hearing so they can get the report to the court on time. For the grandparents that have to be served, a common question is, well, you know, the grandparents either, you know, maybe English isn't their original language. They might live in Vietnam or they live in Mexico. They only speak Spanish or Vietnamese. They're not going to understand the paperwork that they're served with. That's okay. It's still required by law that it's sent to them. Even if they're not involved in the child's life, they don't really know the child. These are all the people on this list are entitled to notice. They just have to be, a copy of the forms just have to be mailed to them. And there's going to be a proof of service form that a server will fill out. The server, you don't have to hire a process server to serve them. You can just find any other family or friend who's willing to do the service for you, and they'll fill out the proof of service form. They just have to, the only requirements for the server is that they're at least 18 years old and not a party to the case. If there aren't any surviving grandparents or brothers or sisters or any of the people up above, then you have to go to second degree relatives. So that's where you can see item G there. If none of the above, then you must serve the aunts, uncles, nieces, and nephews who are at least 12 years old of the conservatee. Other things that you're going to have to do prior to the court hearing is to have the conservatee's primary care physician, or at least a doctor that knows the conservatee the best, complete what's called a capacity declaration. And this is a document that's going to say whether or not the conservatee has the capacity or ability to attend the court hearing and or lacks the capacity, and that the conservatorship is appropriate for them. Other things you'll have to do is have your proofs of service filed showing that you served all the people entitled to notice. And the probate court investigator will start and conduct their investigation. Part of the forms that you'll be filling out as part of the process are confidential questionnaires where you're going to write in information about each of the proposed conservators, the conservatee. You're also going to write in different family members. This is all on one of our local forms, PB 4002, and the confidential supplemental information is on forms GC 312 and GC 314. And all these forms together are going to give the investigator the information they need to make sure that the conservators are the right people for the job. They're going to be contacting relatives who know the conservatee the best, just to make sure that this case is not being open for any improper purposes. You can kind of think of it as a background check. There'll also be a place that you can write in names of friends and family member, people that would be a good reference for you to be the conservator. So to continue in the overview, what to expect at the hearing. They're held on Tuesdays at the courthouse located at 191 North First Street. And you can arrive at the courthouse by 12:30 that day. You can even do practice runs just so you can make sure that you kind of get the lay of the land. You're able to find parking, and if your conservatee is able to appear at the hearing, then they have to be there as well. And so it can be a little traumatic and hard for them, to go through metal detector and to sit still for a court hearing. So for some people find that it helps if you do it like a practice run with them, getting to the courthouse. And on the day of the court hearing, the doors open at 12:45 sharp, and they start by showing everybody a short 23-minute video. And that's going to go over a lot of the information that we're covering today, but it's a great video, informational video, explaining what a conservatorship is, what are the duties and powers of the conservator, what are the rights of the conservatee, and all that. That video is actually shown every Tuesday. So if you want to split up having to watch the video and having your court hearing, you could come on a Tuesday just to watch the video, and then you can leave. There's a paper that certifies that you watched the video, so that the next week when you come to your court hearing, you can skip the video part of it. And then the hearing itself is not very long. There's going to be a calendar with everybody's, all the different cases that are on calendar for that day will be listed. And it's impossible to tell what order that you're going to be called in. So if there's a lot of other cases on calendar, you could be the first case called and you could be in and out of there very quickly, or you might be one of the last cases called, and in that instance, you would have to make sure that you're prepared to be there for the whole afternoon, maybe until 4:30 or so. The hearing itself won't be very long. At this point, it's sort of a formality because the probate investigator and the probate examiner will have looked at all of your documents filed and made sure that there aren't any problems. If you'll know ahead of time if any of the paperwork was not filled out correctly, the probate investigator will have called to let you know if there's any problems with the background check. And you'll even have an opportunity to try to correct any of the forms before you show up. There's a case where the probate examiner let the family know that their proof of service wasn't filled out correctly. They contacted our office. We were able to help them correct the form, get a new one signed before their court hearing. So I want to mention that just in case, just to try to alleviate some of the fear around the court hearing itself and what it's going to be like. Everybody at the probate clerk's office is very helpful, and they want to help out families who are doing everything correctly, and so they will give that feedback if maybe some of the forms aren't filled out properly, give you a chance to fix them. So when your case is called, the names of the petitioner will be called, and so you're supposed to approach the counsel table there in the middle, and the public defender will have met with your family prior to the hearing. And the public defender will probably do most of the talking. The judge may have some questions directly to your family, but it shouldn't take very long at this point. After the court, if the court grants the request to have you appointed as conservators, then the court will sign what are called letters of conservatorship and sign an order after hearing. And so those will be given to you so that you can then take those down to the clerk's office for filing, and you can leave with those. When you end up dealing with financial institutions, a lot of times they'll ask, oh, do you have your letters? Do you have orders showing that you have the authority? And those are going to be the documents that those financial institutions or whatever the institution is, those are the things that they're going to be referring to. So those are the documents that are going to cloak you with your authority. This is also the time when you're going to show the clerk that you have the handbook for the conservators. So you can show them on your phone or tablet that you have it downloaded. Yeah, that's what we were talking about earlier. After you're appointed as conservator, then you have to give notice to all those same people you had to give notice to earlier that you've been appointed. So you're going to be sending out a copy of the order and the notice of conservatee's rights to, again, the spouse of the conservatee if they have one, their parents if it's not you, if you as the petitioner conservator are not the conservatee's parents, you'll send them a copy of those documents. To the brothers and sisters 12 years or older, all the grandparents, the San Andreas Regional Center, and the public defender. So that's for after the hearing. So we made reference to a lot of, there's a lot of different forms that have to be filed as part of opening the case. And you can use the Guide and File program. It's a new program that's out now. Let me see if I have a link here under resources. So you can see their Odyssey Guide and File, and there's a link there. This new program that's out asks what are supposed to be simple to understand questions, and then it'll generate all the forms for you. At the end of that interview, then you can print those out and you can file those the probate clerk's office without anyone reviewing them. It's possible. At the end of that, it also prints out our instruction sheets for, step-by-step instructions for when to serve people, who to serve, getting the capacity declaration signed by the doctor, going to your court hearing, and service of the documents after the court hearing. All of that is generated at the end of the Odyssey guide and file forms. But of course, when you're answering these questions as part of the guide and file program, if you want to make sure that you've answered those questions correctly, that you have all the forms properly filled out, then you can use our office to help you review all those forms in order to get registered. And we do that as part of what we call workshops. We're currently offering 2 workshops a month. We just expanded that very recently. Our CEO is putting a large emphasis on expanding services for civil and probate matters. And so we're very happy that we're getting some more resources to offer that. But because of the high volume, that's why we're sort of moving in this direction of having people first have the guide and file forms prepared for them, and then have us review those as part of the workshop, rather than us preparing all the documents ourselves. It's just such a time-consuming process to prepare them ourselves. So we're trying to get the word out that this is the direction that we're going. At the workshop, we give a similar presentation I'm giving now. However, we go into detail for each of the forms that are required to open the case, so that you, representing yourselves, understand what's in your forms. You can take responsibility for what's in those forms, and that you really feel empowered, that you fully understand the process and know what the next steps are and what to expect. So to ask us for our help, you can see on the screen here, there's a link to our website, and it'll bring you, and there's a picture there on the screen, and this is what the web page looks like when you follow that link. There's going to be a place for you to put in your the name of the proposed conservatee, it's your child, their date of birth, their address, and then your own information so that we can contact you. So I check this email almost every day. So when you fill out this intake sheet, this sign-up sheet for our workshop, what it does is it generates an email to an account at our office that I check almost every day. And what I do is I'll email you back and tell you that you're put in a wait list queue. And all I'm doing, we don't have any backlog currently for this, so all I'm doing is waiting for 12 families to submit these so that I can have a group of 12 to schedule for the next workshop. And so once I have a group of 12, then I send out another email giving you instructions to fill out a questionnaire that's going to ask you, it's sort of like a homework assignment to help you prep for our workshop, to help you gather the information that's going to be required for the forms. It's going to ask you for information about all the different relatives, what their addresses are, what their telephone numbers are. It's going to ask you about the conservatee's diagnosis, the last time they went to their doctor. All of that type of information is all going to be part of the questionnaire, something that you'll have to fill out and email back to us. And we give you about 10 days to 14 days to fill that out, just to give us some lead time before your workshop so that we can make sure all your forms are filled out properly and are all accurate, so that when you come to the workshop, we have all your forms ready and waiting for you at the workshop. And as I was talking about earlier, what we also ask you to do is to go to the guide and file website, answer the interview questions. At the end of the interview, print out or you don't have to print them out, but download all the PDF forms that are generated, and then also email those to us so that we can print those out. We can compare them to your questionnaire. We can make sure all those forms are filled out properly so that we have them all printed out for you at the workshop. Because the guide and file program is new and it's distributed and published to each county in California, we had to make certain modifications to the interview process, give feedback to the guide and file programmers to make sure that it's printing out proper forms for our county. And because it is new, there are some things that we have to correct, give feedback to the company to make sure all the forms are completely accurate and sort of within our customs in our county. And so we just double check all of those to make sure as you answer the interview questions that all the forms printed out properly. So at the workshop itself, what we do is we give a presentation about the common legal terms, go through all the forms, and then an attorney will answer any questions that you might have, and we make sure all your forms properly so that you're then able to go out and file all the forms that day if you have all the required information. And yeah, so we really love helping people, and the program seems to be working really well. I think some criticism or I guess some problems that people have with the current guide and file program sometimes is that even though it's supposed to be designed to be easy to understand, some people find it difficult to navigate some of the questions. Some people may not have internet access to use it. So in those cases, those people just have to, if you're having problems with it, or maybe it's only offered in English. So some people are only Spanish speakers or only speak another language, so they aren't able to answer the questions. If they don't have anyone to help them do it, they can just fill out the questionnaire form and return that to our office, either by email at the email address that I'm emailing you, or you can bring it in person to our self-help center located at the Family Courthouse in downtown San Jose at 201 North 1st Street, San Jose, California, 95113. You can turn in a hard copy of the questionnaire so that we can prepare your forms sort of the old-fashioned way. We'll take the time to do that, just because we don't want anyone left behind as technology, these new forms of online litigation and form preparation is coming into popularity. We want to make sure nobody's left behind in that process. So we'll make sure that the forms get prepared. But before we can do any of that, first you have to go to our website, submit a request to sign up for one of our workshops. That starts the whole process for us to help you out with all this paperwork. Okay, so that's it as far as an overview of the process and how we help people with this. So if Trudy wants to come back on and has any questions that she's gathered up from you guys, I can try to answer those now. Or potentially, we can try to follow up with you later after I have a chance to look at them, and we can send them out that way. But if there's any questions now, I'll do my best to try and field those.
Thank you, Neil. It was fantastic information, and thank you for allowing us to record this so that it's available to people to watch later or share with someone else. It is such helpful information for families and questions I have. So I'm going to start with, how do you add someone to a conservatorship through the self-help court for a conservatorship that already exists?
So in order to add someone, you're going to follow the same if it's a limited conservatorship, you can go to the website that I have up on the slides here, submit a request, and then I think there's a place where it says, is there currently a case open? You can check the box for yes, and under the notes on that intake form, you can write in, we would like to add a conservator to this case. And then so that when we receive that email, then we'll make sure that we have your forms set up. So a lot of the very same forms, it's sort of the same process. If you want to add an additional conservator, we'll just make sure that all the documents are properly filled out for you. It's the same petition, notice of hearing, all those other forms, because who you're asking to add as a conservator, again, the probate investigator wants to do an investigation, make sure they're the right person for the job. They're not asking to be added for any improper purposes. And so all the same sort of procedures have to be followed even if you're adding on a conservator.
Thank you. And what about those families who had a conservatorship set up when they thought they were going to live forever, like me, and need to add an adult sibling who doesn't live in California? Is that possible?
Yes, it's possible to add a co-conservator who lives in another state. The same forms are used, and you'll use the same case that was opened here in Santa Clara County. Again, the cases are open based on where the conservatee lives. And so, yeah, even though the conservator lives out of state, then they can still be added here in this case. And every state has full faith and credit, so any order made in any county or any state will be applicable anywhere else.
Great, thank you. There are some people who have what we might call a developmental disability, but are ineligible for regional center. For instance, fetal alcohol exposure, and they now have FASD, or they have a combination of conditions, FASD with ADHD and mood disorders. Or they have a child who has very high functioning autism and they're ineligible, something we used to call Asperger's syndrome, are ineligible for regional center services. Are they still able to request and petition the court for conservatorship?
Yes. So if you just look back at the definition of developmental disability, it's not contingent on them being a client of the regional center. But as long as they fall within that definition, then they can still apply for a limited conservatorship.
Great, thank you. Let's see, what about doctors who are not cooperative in this process?
So I'm assuming that you have a physician that's not willing to sign a capacity declaration.
Correct.
That's unfortunate. You can always look for another physician who would be willing to meet with your child to do that. I don't have any advice on that. This is an example of sort of a real world practical problem that some people run into. Like trying to locate people for service. How do you locate somebody? Well, you can check social media. You can call and interview, other family members who might know where they are, but it's just sort of like a on the ground practical problem that maybe you're running into, and you just got to get creative with your problem solving. So if this, whatever this doctor has a problem with, maybe that's not a great doctor. Maybe is there an alternative? Is there another doctor you can go to? These are things to consider, I suppose, in that type of situation.
Great, thank you. Somebody asked about successor conservators, but what I heard was they're all equal.
Yes, that's how we set up the forms. I have seen, in estate planning documents for general conservatorships, or let's just pretend that you wanted to plan on for the day. If I was having an estate plan done, if I were to become disabled or incapacitated, and I want to propose different conservators for me, I might put in my estate planning documents that first I want my wife to be my conservator if I'm not able to manage my affairs. But if she's not around or not able or not willing to be my conservator, then I want to nominate my brother. And then after that, I might choose, my sister. And so you have this sort of succession of people to act in case the other person does not want to or is unwilling to or unable to serve as your conservator. But the way that we set up the docs for the limited conservatorships, we don't do the successive proposed conservators. We do them all with equal powers to all act now. That's not to say that it may not be a possibility to do, but that's because the language that would be required for that, you want to make sure that there's a plan for what are the conditions that have to be met in order for the conservator to step down, or how do you determine if they're not, maybe they end up lacking the capacity to be a conservator? What are those requirements? And what's the succession plan? And what documents have to be filled out to acknowledge that they're no longer responsible for that, and the alternate is to then take their spot. And so because of the complications of that type of wording and arrangement, we don't help with that when we help fill out the forms. We have it just so that every proposed conservator has equal powers. So just up front, make sure that you're selecting people that you get along with and people that you think would do a good job at it. So that the successive conservators is not something that we help set up the forms with for all the reasons that I said.
Would an attorney be able to do that for someone?
Yes, you could consult with a private attorney to see what that alternative is, if they can help you with that wording in the document.
Great, thank you. In Santa Clara County, we have a very diverse population. We have families who have immigrated here from other countries, and all of their family is in another country, be it Mexico or Iran, or, well, I guess Iran doesn't, yeah, I mean, wherever they are. How do you prove to the court that there is no family member in the country? And if not, would they want to reach people outside of the country to notice them of your intent to conserve?
This is a great question, a very common question. We very often, we have all of our, grandparents on both sides live in just a remote region of Mexico. There's not actually a physical address. There's just sort of village there. They don't have their own telephone, and so you're going to fill in the most information that you have about those people in the form, like their full names if you can get it, their address if known, their telephone number if known. But if you're not able to provide an address or telephone number, there will be a place on the forms where you're writing in what's called your due diligence to try to obtain that information. All the efforts that you made to obtain that information, including calling or emailing or messaging family members, phone book if one exists for that area, social media, and after all of these efforts, if you still can't find all the information, then you're just going to write all that in there, and basically the court will waive the requirement that you provide them notice because you're not able to locate them. Some people can't be located because they're deceased, and if that's the case, then you're going to write, maternal grandmother is deceased on the forms. And so, but there's just the requirement that each of the people that are entitled to notice, you have to describe your efforts to obtain their address, and if you're not able to obtain it, then you say what you did to try to find it, and then the court will, if you've done enough, then the court will give you permission to then you won't have to notify them.
Great, thank you. If you're adding someone to an existing conservatorship, do you have to go through that same process?
Yes.
Okay. All right. Here's another question. How does the self-help court, or does it, serve monolingual families, especially Spanish and Vietnamese?
Yeah, so if you are in need of an interpreter at but first, before we even get to the, let me just say this, for all services, there are Spanish and Vietnamese interpreters available in the courthouse, but they're only available for interviews, and they're not allowed to help people set up forms. So we're just limited in that it is what it is. That's what the court policy is on that front. So what we do is we always encourage people that are going to be attending our workshops to bring an interpreter with them and somebody that could read and write English as well, so that if they need help with any of the forms, they have that person there with them. The presentation is done in English. All the forms that have to be filed with the court are required to be in English. And our intake questionnaire and registration, the website, it's all in English. And so they're going to have to rely a lot on getting help from friends and family, or there's some I think some Catholic charity organizations or other organizations offer free interpretation services. They're encouraged to try to do some research to see if they can arrange to have someone come with them to our workshop to make sure that they're able to help interpret the presentation, and also to make sure that they understand what are in the forms, and if any changes need to be made to the forms, that their interpreter can help them fill out the changes.
Thank you. Another question. Somebody has a diagnosis of bipolar disorder. What type of conservatorship would be available, if at all?
I'm not sure if bipolar disorder will qualify them as a developmental disability, because if it's properly medicated, then theoretically, unless there's some other diagnosis or disability that they have that's going hand in hand, that's also impacting them, that may not qualify them. If you I have the definition of developmental disability up right now, but they should just read through the other slides about what the other conservatorships are. If they are refusing treatment and it's very severe case, maybe a county agency would start an LPS conservatorship for them. I'm not sure. Generally, just bipolar disorder itself, I haven't seen that one require a conservatorship.
Okay, thank you. Here's kind of a sad question. What if everybody who's a conservator dies?
Yeah, it's a very sad question, but it's a reality that people have to try to plan for. So if everyone dies, then hopefully there'll be somebody else that knows about what happens who will step up and petition the court to be appointed. It can help if you do go to a private attorney and have an estate plan drawn up for your family, if you can afford to have that done for you, or there's some volunteer legal services organizations. I know Alameda County has volunteer legal services for residents of Alameda County, where they have pro bono attorneys who will prepare estate plan documents. And in those, you can sort of plan for what would happen if you were to pass away. Who would you nominate to kind of take over either a special needs trust for your child, or who would you like to be the one to try to step in there and help out your child? If not through estate planning documents, then can you have those conversations with other people, and just so that you sort of manage expectations and have a plan in place. I know it's a difficult conversation to have, but this is, it's one that maybe needs to be had so that you can take care of this child.
Thank you. I also want to mention that there's the Good Shepherd Foundation who will take over, and I don't know what their fees or anything are, but there's frequently sessions. Maybe we can get them to do a webinar for us as well. So that's one source.
That's a common problem that some people have and hard to plan for. So if there are other organizations that offer that type of service, or what are the alternatives? What does it look like for the conservatee, when they're sort of unfortunately left all alone very suddenly without any planning? What's supposed to happen next?
Well, the other thing that I want to add, if they are regional center clients, regional center will assume the responsibility as well.
Great.
Well, let me ask another question. This was a clarifying question that someone had. If the probate investigator recommends that some of the rights not be granted, such as the right to vote, can you ask the judge to overrule that?
Yes.
Okay. Secondly, does the court investigator and the public defender's office come to the home to meet the son and the daughter that might be being conserved, or the sibling?
I don't know if they do that in every case. I know that phone calls are made, but I think they do that on a case-by-case basis, maybe depending on what they find out from their initial phone calls. They'll take follow-up action. I think they also might follow up with the family even after the orders are granted, just to kind of check in to see how things are going too. I've heard that as well.
Okay.
But I don't know for sure in every case if they do a home visit.
Okay. Are there other counties that you know of in our general region that are doing this, the self-help?
Every county has a self-help center. I don't know if I know for sure not every county is offering assistance with limited conservatorship specifically. I know it's something on many counties' radars to expand their services to offer it. The majority of counties, and even ours, focuses mostly on family law issues like custody, child support, just because that's the large majority of what cases are coming to court for, what many families are coming to court for. And so a lot of the probate and civil matters, there's a little less funding for those types of issues. But because we've seen such a strong response and need in our county. In partnership with San Andreas Regional Center, in partnership with Parents Helping Parents, we've discovered that this is a service that a lot of families are interested in, a lot of families are in need of. And so as we've expanded our workshop and our service, we're meeting the demand that we've found. And so we're assuming that other counties are going to have a similar demand, but they don't really know about it because they haven't really built the services yet. Kind of if you build it, they will come thing.
Exactly.
And so I do know that some of the surrounding counties do offer, I don't know specifically which ones, but some of them do offer some assistance with limited conservatorship. I'm not aware if anyone is running at least around here, a full workshop as often and to the level that we are. We're trying to model ourselves after, I think it's either LA or Orange County has a very large center that's focused solely on limited conservatorships, general conservatorships, and guardianships. And they found that they have a huge need there, and we're finding a similar need here. As word gets out that we're offering this service, more and more people are being able to take advantage of it, and it's really great.
Thank you. If you move out of the state, does your conservatorship travel with you, or do you have to repeat this process in the state of residence?
It's still, the orders made in this case are good anywhere else in the United States. Each state has full faith and credit for any orders and laws made in other states.
Okay.
You don't have to open a new case and get new orders if you move somewhere else.
Okay, thank you. But in order to attend the workshops in Santa Clara County, you have to live in Santa Clara County, or the person you're conserving must live in Santa Clara County. Is that correct?
That's correct.
Okay, great. Somebody's asking if an 18-year-old who is a twin of somebody or a sibling of any type, can they be listed as a secondary conservator?
Yes, as long as they're 18, they can be a proposed conservator.
Okay, great. And somebody's interested in the Good Shepherd Foundation. Is there a difference in what should be done for the conservatee between conservators, and does the court give more preference of the parents' wishes over the conservators? So I'm going to guess, and I'm going to ask that person to let me know if they're looking for a conservator that's not a parent, because I think that I need a little clarification for that. And it's William. William, I'm going to just, if it's okay with you, I am going to give you the floor so that you can speak and just ask that question. You now are able to speak and we can hear you.
Yes, thank you, Trudy. I assume, Neil, you can hear me?
Yep.
Yes, I can.
Okay, so the question is this, you do your best to try to find conservators that you generally agree on decisions for the conservatee, but there may be some unanticipated differences of opinion on a matter as it relates to that person, the conservatee. Does the court in general provide a preference to what the parents of the conservatee want over the other conservators who may disagree with what the parents want to do in this case?
Okay, I understand your question. No, so after the proposed conservators are appointed, they all have the equal powers. The analysis the court's going to be making is what's in the best interest of the conservatee. Very similar to what we see in kind of custody cases for family court. And so there's going to have to be a rationale, an explanation of what the problem is. The history is going to be very important, case by case, and what the proposal, what the solution is, and the court's just going to look at that on a case by case basis. And I don't believe they're going to give any more preference to a parent over if it's an aunt or uncle or brother or sister or someone else, because at this point all have been vetted by the probate court as all being the appropriate people to be co-conservators and all sort of have equal powers.
I see. All right, thank you very much.
Thank you. There is another question, but I want to give the opportunity for something that's popped into your head and you couldn't find the question area to raise your hand. So there is the ability to raise your hand with one of the options on your control panel. And while you're doing that, I am going to ask the next question. Is there a limit to the number of conservators?
Not that I'm aware of. I think the most that I've helped somebody fill out was 4 or 5 proposed conservators. I haven't seen anyone ask for more than that, and I don't know I didn't follow up with that particular case to see if all were granted, but I didn't hear back that they weren't. So I don't think that there's necessarily a limit on that.
Okay, thank you. Last chance to raise your hand to ask a question live. I feel like, you know, Trudy Gross on NPR or whatever that station is. Or no, it's Terry Gross. Okay. I'm not seeing any hands coming up, so I think you have answered all the questions, and the questions that we got addressed probably a number of people's interest areas. And I do want to mention one thing, is early on in the presentation, there was a discussion about inheritance and lawsuit funds that would need the conservatorship of the estate. I just want to say, if by chance somebody's grandma died, and I see your hand up, somebody's grandma died and left $250,000, which is going to boot that person right off of public benefits, there is the ability to set up a first party trust, but you will need an attorney, and the court will monitor how those funds are spent. So I have just put the microphone on for N.
Hi, thank you. This is Neiman here. I had a quick question on the workshop that the self-help court is doing. How much before the conservatee is turning 18 should one sign up for the workshop, since you said that it takes a little time for you to basically get a requisite number of people to hold one?
Sure, yeah. So if they're 17 and a half, that's an okay time to submit a request to register for a workshop. But as I also said, we don't really have a backlog. It only takes a few weeks for me to have a full workshop, and so it only takes a few weeks before I send out confirmation for when the workshop it'll be. And so from the time you submit a request to register for a workshop before your workshop actually happens, it's about a month or so. And then when you leave the workshop, when you have all your forms prepped and ready, when you file them, you'll get a court date in 2 to 3 months. So if you're at 17 and a half, that'll put you right around the time your child's turning 18 when you have your court orders and everything.
Okay, and about the time that you request a workshop, is my understanding correct that we should be doing the maybe guide and file process around about the same time?
So when you register for the workshop, we'll send you an email with all those instructions. It'll have in that email the questionnaire that you'll fill out and return, and it'll also have a link to guide and file with instructions for you to complete that interview and to email us the forms generated by the guide and file program.
Okay, thank you very much.
I have time for one final question, and that question is, we often are hearing from families whose teacher, well-meaning teacher or someone else has told them that they have to get conservatorship before the child turns 18. What is your response to that?
So a conservatorship cannot be granted prior to them obtaining, it can be granted, but it won't be in effect until they are 18, because conservatorships by definition are just for adults. And when they're under the age of 18, then they're your child and you have authority over them as their child, as their custodial parent. So it's okay if your court hearing ends up, like a month, or it's really close to the time that they're turning 18. and that's okay, but it's not absolutely necessary to obtain a limited conservatorship, or at least have the hearing on it before they turn 18. Because, like I said before, as a parent, you have authority over them as their guardian, as the custodial parent.
Great. And I'm going to assume if you're going through the process before your child's 18, they don't have an income, but you're still responsible for them. So are they going to base the fees on the parent's income if they go to the court appearance before the child is 18?
No, it's always based on the conservatee, even if they're under 18 while they're filling out the forms.
Beautiful. All right. I think that's it. We're going to wrap it. You've been wonderful. I'm getting thanks from people who are online. It was very helpful. And just, I can't thank you enough. So I hope we can do this again sometime. And we'll see you in court. We're at the class. All right. Thanks so much.
Everyone out there.